went through a full custody battle and you received a final order, but things have now changed. So the big question is, what do you need to show to modify custody orders in Wisconsin? Here's the truth. Changing custody orders after a divorce isn't easy, and the courts don't revisit it just because someone's upset. In this video, I will show you the 3 events that trigger custody reviews, how long you have to wait after your original order, what a substantial change in circumstances really means, and why the burden of proof is way higher than before. So custody modifications, when is it possible? Let's begin with the first rule. You can't just change custody anytime you feel like it, nor can the other party. Wisconsin law sets strict limits to avoid back and forth custody battles. But there are 3 specific instances where a judge will reopen a case and entertain changing the order. So trigger number 1, it's been 2 years since the last custody order was entered by the judge. So if it's been 2 years or more since your last and final custody or placement order, then the judge can modify the order if there has been a substantial change in the circumstances related to your children. Not just because things are a little bit different, it has to be substantial. And that includes things like a parent relocating out of the state, a child developing new medical or educational needs, or there's been a change in a parent's ability to care for their child. And that could be job loss, mental health issues, substance abuse, etc. Now, if it's been less than 2 years, you're not completely out of luck, but the standard is even greater. Trigger number 2, the child is in danger. And this applies no matter how many years have gone by or not gone by since the last order. So if it's been less than 2 years since the last custody order, you can still request a change, but only if the child's physical, mental, or emotional health is at risk. Now, this means there must be evidence of abuse or neglect, parental substance abuse or criminal activity, or unsafe living conditions. Judges are extremely cautious about modifying orders too soon. They don't want parents relitigating old arguments, but when a child's safety is truly endangered, that changes everything for a judge. And those are high stakes. I recall once we had a client whose daughter was missing school constantly after switching households. And once we gathered the school records, the medical notes, and the text messages, we had the evidence that we needed to prove harm to that little girl. That custody order was changed, but it took a lot more than just concerns. So that brings us to trigger number 3. Both parents agree. And you can do this at any time. Both parents can agree to modify the court order. That's it. They just need to agree, memorialize that, sign it, and send it to the judge for signature. And the judge will sign it so long as, again, it doesn't harm the child and it does not violate any public policy or law. Now let's switch over to the big one. What is a substantial change in circumstances? And this is where most people get tripped up. The law does not give a one-size-fits-all definition. That means that it's up to the interpretation of the court, and it's important to know how judges interpret these matters to know if it applies in your case. A clear example is that there's been a significant life change that affects your child's well-being. Something that was not reasonably foreseeable back when the original order was entered. And some examples that almost always qualify is when one parent is moving more than 100 miles away. Now remember, since 2025, Wisconsin uses driving distance, not as the crow flies. Another is when a parent gets a job that drastically changes their availability. So think they went from like first shift to third shift. Or the child's needs have changed. That could be medically, educationally, emotionally, mentally. And another is when one parent is simply no longer following the original court order. Now let's flip that coin. What are some examples that are not a substantial change in circumstances? Well, a big one is when the child says they want to live with me now. Sorry, that's not big enough for the court. Another is, well, my ex has a new partner that I don't like. And a big one that we hear often is that the old agreement just is not fair anymore. Maybe it's not, but that's not going to be enough for a judge. I recall once a lady asked me to reopen the custody order because she just simply cried every time that the child went over to the dad's. But the court would not be persuaded with just that alone. So that is why you need strong evidence, not just opinions, a solid legal strategy, and documentation. Get as much as you can. School records, police reports, messages, emails, third-party testimony, whatever. That all can add up. And remember, The standard is best interest of your child, and that proof is upon you if you take it back to court. And while custody modification is tough, it is not impossible. And if you're at the start of a divorce process, your original custody plan matters more than you realize. That's why we created a video on the first things to do when filing for a divorce in Wisconsin. So watch that next so you don't set yourself up for a custody battle later.